others. The court had the following to say, and we quoted from it. In summation, the doctrines of ripeness and constitutional avoidance shun to deal with a constitutional issue where there exists another legal cause which can give the litigant the reliefs he seeks. In other words, a constitutional issue is the only cause that can give the litigant the remedy he seeks. Both constitutional avoidance and ripeness avert the determination of the constitutional issues until it becomes necessary, to the extent that it is the only cause available to assist the litigant's cause. End of quote. We also relied on Farage and 3 others versus Police and 2 others to support that doctrine. So then what was our conclusion? Having acknowledged that the predominant issue is whether the provisions of the Affordable Housing Act are in conflict with the Constitution, it is our considered view that that doctrine of avoidance is inapplicable to the petitions as consolidated. I'll invite my colleagues to consider to read our judgment on the second issue, and that is whether the Act is constitutional or not, and they'll share that both Justice Mungare and Justice Chigiti.
Having disposed of the technical points, we now turn our attention to the merits of the petitions. The brief background is that by a judgment of this court, differently constituted, various provisions of the Finance Act 2023 were declared unconstitutional. One of the nullified provisions was Section 84 of the Act, which sought to amend the Employment Act in the following terms. And I quote Section 84 of the said Act. The Employment Act 2007 is amended by inserting the following new sections immediately after Section 31A. Insertion of new section of number 11 of 2007, Affordable Housing Levy, that 1B, notwithstanding the provisions of Section 32A, B, C, and D of the Act, each employee and employer shall pay a monthly levy to be known as the Affordable Housing Levy. 2. The purpose of the Affordable Housing Levy shall be to provide funds for the development of affordable housing and associated social and physical infrastructure, as well as the provisions of affordable home financing to Kenyans. 3. The Affordable Housing Levy shall not be used for any other purpose other than development of affordable housing and associated social and physical infrastructure, as well as the provisions of the affordable home financing to Kenyans. 4. The monthly levy payable by the employer and the employee shall be A. 1.5% of the employee's gross monthly salary for the employee and 1.5% of the employee's monthly gross salary for the employer. In the judgment aforementioned, the court expressed the view that Section 84 proposed to introduce a new levy known as the Affordable Housing Levy without a proper statutory framework to govern the imposition and administration of the levy. Accordingly, the court held that the provision was in conflict with Article 210 of the Constitution. The provision was therefore declared unconstitutional. However, the court granted stay pending the enactment of a substantive legal framework. It accordingly ordered as follows: that the introduction of the housing levy through amendment of the Employment Act by Section 84 of the Finance Act 2023 lacks a comprehensive legal framework in violation of Articles 10, 201, 206, and 210 of the Constitution. The imposition of the housing levy against persons in formal employment with the exclusion of non-formal income earners to support the national housing policy is without justification, is unfair, discriminatory, irrational, and arbitrary, and in violation of Articles 27 and 201 of the Constitution. The fourth respondent proceeded with speed and published the Affordable Housing Bill, number 75, by Kenya Gazette Supplement number 236 of 4th December 2023. It was processed and passed on the 21st February. The bill was thereafter of 2024. The bill was thereafter forwarded to the Senate on 12th March 2024, and upon being passed was given presidential assent on the 19th of March 2024. Sections 4 and 5 of the Act became operational immediately by dint of Section 1A of the Act. It was on the same date that the President appointed the chairman of the board. The rest of the provisions were operationalized on 22nd March 2024 by a special issue of the Kenya Gazette Supplement number 70 of 21st March 2024 through Legal Gazette number 54. The court takes judicial notice pursuant to Section 85 of the Evidence Act that following the operationalization of the Affordable Housing Act, the respondents proceeded to implement the Act by Gazette Notice number 4350, 4351, and 4351 of 12th April, and Gazette number 4495 of 17th April 2024, where the CS Lands appointed members of the board. It was the operationalization of the Act that precipitated the filing of the petitions. It is trite that statutes enjoy the presumption of constitutionality, and thus the onus was on the petitioners to establish that the impugned Act is indeed unconstitutional as alleged. We bear in mind that the burden of proof is on the petitioners to prove all the aspects of their petitions to the requisite standard. The Supreme Court, in the case of Samson Guer and 5 others, versus Kenya Medical Research Institute and 3 others, stated as follows, and we quote from paragraph 47 of that judgment. It says, "It is a timeless rule of the common law tradition, Kenya's juristic heritage, and one of fair and pragmatic conception that the party making an averment in validation of a claim is always the one to establish the plain veracity of the claim. In civil claims, the standard of proof is the balance of probability. Balance of probability is a concept deeply linked to the perceptible fact scenario. So there has to be evidence on the basis of which the court can determine that it was more probable than not that the respondent bore responsibility in whole or in part." This position was reiterated by the Supreme Court in Wamwere and others versus the Attorney General, and we have cited the holding of the Supreme Court, which said a petitioner bore the burden to prove his or her claim of the alleged threat or the violation of the rights and freedoms of the requisite standard, which was on a balance of probabilities. Such claims were by nature civil causes. The onus of proof was on the first appellant to adduce the sufficient evidence to demonstrate that she owned or erected or lived in the alleged properties, and that state agents interfered or deprived her of the subject properties. That was the import of Section 107 of the Evidence Act on the burden of proof. End of quote. We further cite the decision in the Council of County Governors versus the Attorney General by the mastivo judge, as he then was, and I will not read that, but we have lifted a bit of the ruling on the general presumption that every act of parliament is constitutional and the burden of proof lies on every person who alleges otherwise. Further, in the East African Court of Appeal, in the case of Danambo versus the AG, the court held that the Constitution is a living instrument having a soul and a consciousness of its own. Courts must endeavor to avoid crippling it by construing it technically or in a narrow spirit. It must be construed in tune with the lofty purpose for which its makers framed it. Fundamental rights have to be interpreted in a broad and liberal manner, ensuring that our people enjoy their rights. Our young democracy not only functions but grows, and the will and dominant aspiration of the people prevail. End of quotes. The guiding principle in determining whether the sections of an act of parliament are unconstitutional were succinctly laid out in the case of Institute for Social Accountability and another versus the National Assembly, where a three-bench of this court held as follows. First, that this court is enjoined under Article 259 of the Constitution to interpret the Constitution in a matter that promotes its purpose, values, principles, and advances rule of law, human rights, and fundamental freedoms in the Bill of Rights, and that contributes to good governance. In exercising its judicial authority, this court is obliged under Article 159 of the Constitution to protect, promote the purpose and principles of the Constitution. Additionally, we also looked at the petition of number 150 of 2016, which was consolidated with petition number 234 2016, Attorney General, E.G. and others versus Attorney General, where the three-bench judge held that the technique of paying attention to context in statutory construction is now required by the Constitution. As pointed out earlier, the Constitution introduced a mandatory requirement to construe every piece of legislation in a manner that promotes the spirit, purport, and objects of the Bill of Rights. The purpose of statute plays an important role in establishing a context that clarifies the scope and intended effect of a law. The often quoted dissented judgment of Schreiner J.A. eloquently attributes the importance of context in statutory interpretation he went on to say that certainly no less important than oft-repeated statement that the words and expressions used in a statute must be interpreted in according to their ordinary meaning in the statement, and that they must be interpreted in light of their context. But it may be useful to stress 2 points in relation to the application of this principle. That first is the context, as here used, is not limited to the language of the rest of the statute regarding as throwing light of a dictionary kind or of the part to be interpreted. Often of more importance is the matter of the statute, its apparent scope and purpose, and within limits its background. We further cited the case in SBM and another versus the Attorney General. Is a Supreme Court decision that states that it's unassailable that the approach to interpreting fundamental rights and freedoms in the Bill of Rights by this court has to take the model of looking at the Constitution as a whole, which is purposive and generous, giving effect to the constitutional values, including substantive equality. In reaction to inequality and discrimination advanced by the petitioner in Prince Lu versus this is a South African decision, where the court said it is convenient for descriptive purposes to refer to the differentiation presently under discussion as mere differentiation. I'll not quote the end of that ruling, but I'll go to the next broad issue. Under the broad issue of constitutionality, we identified the following points for determination. 1, whether there was adequate public participation. 2, whether the Affordable Housing Act violates Article 27 and 40 of the Constitution. 3, whether the Act infringes on Article 43 of the Constitution. 4, whether or not the Act amounts to a clawback on devolution. 5, whether the use of public land for development of affordable houses infringes on the functions of the National Land Commission. And 6, whether the Act is unconstitutional for failure by the CRA to consider the bill as per Article 205(1). On whether public participation was undertaken, the petitioner has argued that the enactment of the Act was not done in conformity with the various tenets of the Constitution, one of them being public participation. While they concede that some measure of public participation was conducted, it was their submission that it was not sufficient. It was therefore their case that at best, what was done was a cosmetic exercise and a waste of public resources. The petitioner has argued that whatever was done by way of public participation went contrary to Articles 10, 118, and 201 of the Constitution. In particular, the petitioner has argued that the invitation notice to members of the public to present memoranda on the bill by the National Assembly within 7 days was too short, and thus the purpose of public participation cannot be said to have been achieved. Similarly, they contend that the deliberations of the Senate at the second and third reading stages was also constrained, with the result that it limited public participation 7 days only, such that no public hearings could be conducted in any of the 47 counties. The petitioners also took issue with the fact that public participation was only conducted in 19 counties. They pointed out that 28 counties were excluded from the exercise in blatant violation of Article 10(1), 2A, and 27 of the Constitution. That the discrimination of the petitioners went further to state that the discrimination of the 28 counties and the refusal by the committee mandated with the conducting public participation or collecting views of the persons from the 28 counties was in blatant disregard of Article 47 of the Constitution of Kenya 2010, as read with Sections 4 and 5 of the Fair Administrative Act 2015, that require administrative action to be expeditious, efficient, reasonable, and procedurally fair. In addition, the petitioners submitted that although public participation was conducted in 19 counties, it was non-quantitative, non-qualitative, and therefore rendered meaningless. It was argued that public participation was conducted only in 19 counties, while the National Assembly executes its mandate in 290 constituencies. The petitioners further argued that lack of proper public participation is evident from the reports of the National Assembly and the Senate. It was their case that the National Assembly and the Senate did not provide adequate opportunities for people's involvement in the legislative process of the Affordable Housing Act. In the same vein, the petitioners also submitted that Kenyans had legitimate expectation that the Constitution would be followed in conducting public participation. In conclusion, the petitioners urged this court to find that the Affordable Housing Act did not meet the constitutional parameters for public participation under Articles 10, 118, and 201 of the Constitution. In their response to this question on public participation, the respondents did not dispute that public participation is a requirement of the Constitution. To illustrate, the National Assembly indicated that it conducted civic education in languages comprehensive to the diverse communities in various locations before public participation sessions were conducted by providing fact sheets that gave information to the Affordable Housing Bill. In addition, advertisements in the local daily newspapers were done inviting the public to submit views on the bill by the deadline of 28 December 2023. Key stakeholders were invited to participate to make oral presentations before the committee in sittings that were held in Parliament buildings on 29 and 30th January 2024, 6th and 7th February 2024. The respondents submitted that public hearings by key stakeholders were held on diverse dates across 19 counties that included Narok, Kisii, Homa Bay, Vihiga, Uasin Gishu, Turkana, Baringo, Nyandarua, Nakuru, Machakos, Kirinyaga, Embu, Kiambu, Wajir, Tana River, Lamu, Kilifi, Mombasa, and Nairobi County. Additional meetings were held on various dates with the State Department of Housing, the National Treasury, and the State Law Office, among other government agencies, that allowed various agencies to make presentations to the joint committee. It is the National Assembly's case that it received and reviewed written memoranda submitted by the public and invited stakeholders. It is further the National Assembly's case that the majority of the stakeholders were overwhelmingly supported the bill, noting that promotion of investments in affordable housing has a multiplier effect on the economy through creation of employment, improved supply chains for the construction materials, and consequently will improve the general public. According to the National Assembly, the assessment of Parliament's compliance with its obligation to facilitate public participation in the legislative process is guided by the principle of reasonableness, and there is sufficient evidence to demonstrate that the Act was procedurally and legally subjected to public participation per the Constitution and the standing orders of the House. As a result, the National Assembly urged this court to find that the Affordable Housing Act was compliant with the provisions of Article 10 and 118 of the Constitution. The National Assembly and the Attorney General alleged that the question of public participation had already been determined by a court of concurrent jurisdiction In the case of appeal versus Attorney General and two others, that is the Kisumu petition, on February 29, 2024, where the court found that public participation in respect of the Affordable Housing Bill was compliant with the provisions of the Constitution. The Senate also asserted that the public participation in the Act was conducted per the law and its standing orders, and there was no requirement for public participation in the 47 counties as alleged. It denied that senators were gagged from fully and freely debating the bill and argued that there was no proof provided to this court by the petitioners to discharge that duty. On their part, the KRA indicated that the rate of 1.5 was picked, which was picked from the Finance Act 2023, was on reasonable grounds that it had undergone proper public participation, channels, stakeholder engagement, and the rationalization process, which proposed a reduction of the rate from the initially proposed rate of 3% to 1.5%. It was their case that the High Court judges did not counter the constitutionality and validity of the rate in the petitions challenging the Finance Act. The respondents' assertion that public participation was conducted within the principles of the Constitution was supported by the 10th respondent. I think this is the 10th interested party, COFEC. It was the COFEC's argument that the public participation was conducted within the confines of the Constitution, and that the opinions of Kenyans with regard to the provision of the collection of the levy of affordable housing by the state were considered before the impugned law was enacted. Having considered the foregoing arguments, it's important that this court first dispenses with the issue on public participation being res judicata in reference to the case of appeal. The respondents have stated that the issue of public participation at the National Assembly ought not to arise in this case, as the court already determined that it was compliant with the provisions of the Constitution. Conventionally, the doctrine of res judicata is designed to bring finality to litigation and to provide parties with closure and relief from the burden of being troubled or pursued in connection with issues and lawsuits that have already been resolved by a court of competent jurisdiction. And this is the holding in the Supreme Court in the case of Kenya Commercial Bank by Mwiri and Mwiri Coffee Estate Limited. I will not rehash what the Supreme Court said. The Supreme Court also reaffirmed on the side case and cited the case of John Florence Maritime Services and another was the Cabinet Secretary of Transport and Infrastructure, where it goes on to explain the principle of res judicata. The Supreme Court held that a court has discretionary powers to interrogate the matter before it and determine whether it may occasion substantial injustice to the parties, and in the alternative, it must be convinced that there are special circumstances that allow it to make exceptions to the doctrine of res jurisdiction. This court has perused the appeal case and noted that the petition before the said court was pegged on the impugned notice dated 9th December 2023, issued by the National Assembly in the local dailies, requiring public participation by way of submissions of memoranda for the Affordable Housing Bill number 775 of 2023. The said court noted that the petition only challenged, this court noted that the petition only challenged this mode of public participation on the ground that marginalized communities or persons living in the slums of Korogosho, Mathare and Kibera were not able to submit memoranda in the manner prescribed. The court has also looked at the issues raised on public participation in the 6 petitions, herein vis-a-vis the issues raised on public participation in the appeal case. It is our considered view that the issues raised in the instant petitions raise a broader question as to whether public participation was conducted at the National Assembly and the Senate within the tenets of Article 10, 118 and 201 of the Constitution, while in the appeal case the issue was specific to the mode used to conduct public participation. In any event, the court found that the issue was not ripe for determination, as the National Assembly did not only require submission of memoranda, but also held public hearings as a mode of public petition. And we've cited the decision at paragraph 47, and 48 and 73 of the appeal court. We find the circumstances that the issue of public participation is not res judicata, and now proceed to consider the issue substantively. It is undeniable that public participation is essential to the legislative and policy functions of government, both at the national and county levels. Public participation is integral to the legislative enactment process. Under Article 10(2)(a) of the Constitution, public participation is one of the key national values and principles of governance. Article 118 of the Constitution provides as follows: Parliament shall A, conduct its business in an open manner, and its sittings and those of the committee shall be in public. Facilitate public participation and involvement in the legislative and other business of the Parliament and its committees. Failure to ensure public participation is fatal. Any action requiring it that proceeds without such involvement is invalid, as it violates an explicit constitutional mandate. This was the holding in the case for Doctors for Life versus the Speaker of the National Assembly and others. I think this is a South African decision that is widely cited. We are certain that public involvement was crucial prior to the enactment of the Affordable Housing Act. Public participation must be authentic, not just symbolic, and should not be treated as a mere formality to comply with constitutional obligations. It is important, therefore, that this court answers what defines proper and reasonable public participation as envisioned in the Constitution. We cite the decision in the South African case of Minister for Health and another versus the New Clicks, South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was as held in the case of Muico Basin versus